Live 10 tonight. When AI harms you, can you even prove it? The liability gap and the two laws Europe wrote to close it. One passed and one was withdrawn. And this is the subject for conversation tonight. For 9 nights, we stood on the battlefield, autonomous weapons, the laws of war. Who is accountable when a machine kills? Tonight, we walk into a courtroom and the question gets closer to home. An AI system harms an ordinary person. A flawed medical recommendation, a discriminatory loan denial, a defective automated product. You want to be made whole. So you sue. And here is tonight's puzzle for each one of you. Live premiere, live chat right now. To win, you must prove what went wrong and who caused it. But the AI is a black box that not even its developers can fully explain. Can you actually meet that burden? And has the law just made it easier for you? Or has it quietly left the hardest cases exactly where they were? On you, the person who was harmed. Hold that question. We resolve it by the end of this presentation. But before I go on, your instinct in the comments below right now when we are on live chat during this live premiere 10. If an AI system harms you and no one can fully explain why it did what it did, should the burden of proof be on you or on the company that built it? Type you or them. Live chat, drop your call. I'll read the room before the reveal. And the honest legal answer is more uneven than you would think. Good evening and welcome back to my channel, the AI Law, Global Security, AI Risks and Liability. And this is the AI Law Daily series. That is Thursday until Sunday every week, now at 6 p.m. CST. I'm your host, Nupur Mitra, a techno-legal analyst and a lawyer by profession. And this is your weekly live analysis at the intersection of artificial intelligence, international law, and the governance gaps, collisions between them. For 9 evenings, we mapped the battlefield, the accountability gap when an autonomous weapon strikes, the doctrines states use to escape it, the standards no one has defined, and we ended Live 9 with a turn from mapping the gaps to closing them. Tonight we take that turn and we bring it home off the battlefield and into ordinary life. Because the same problem that makes it hard to hold anyone accountable for an autonomous strike makes it hard to hold anyone liable when everyday AI harms an ordinary person. This is the civil law twin of the accountability gap. It is called the liability gap. And tonight, we watch a lawmaker try to close it, succeed halfway, and walk away from the rest. Let us build the architecture from first principles here on this channel live right now. To win almost any liability claim in tort or in product liability, a person harmed must prove some version of 3 things. That something was wrong with the product or someone's conduct, that they suffered damage, and that the one caused the other. Causation, For a defective toaster or a faulty brake, difficult but doable. For AI, each of those steps can quietly break. 4 reasons documented across peer-reviewed literature. First, opacity. Black box models obscure their own decision logic, which, as researchers put it directly, prevents plaintiffs from proving defect or negligence. Second, complexity. A system with billions of parameters makes it genuinely hard to trace an outcome back to a specific cause. Third, distributed responsibility. The many hands problem. A single AI harm may involve the data provider, the model developer, the company that deployed it, and the user. Who exactly is liable is the question. Fourth, autonomy. A system that learns can behave in ways its developers never anticipated, breaking the traditional chain of causation entirely. The result is a burden of proof crisis. Peer-reviewed analysis is blunt. Traditional but-for tests of causation are intrinsically limited when applied to black box machine learning systems. And because the person harmed rarely has access to the system's inner workings, the information asymmetry means proving causation can require costly expertise and discovery, if it is possible at all. The predictable outcome, in the words of the scholarship, is systematic under-enforcement, victims who cannot prove their case, and careless deployers who are never deterred. That is the gap. Now watch someone try to close it. In September 2022, the European Commission proposed 2 instruments designed to work as a pair. Together, they were meant to close the liability gap. One survived, one did not. The first, the revised Product Liability Directive, this one passed. Directive EU 2024/2853, adopted on the 23rd of October 2024, with member states required to transpose it by the 9th of December 2026. And it does something quietly historic. It explicitly redefines product to include software and AI systems. Software developers and AI providers are now treated as manufacturers for liability purposes. It keeps strict liability. The harmed person does not have to prove negligence, only that the product was defective and that they were damaged and that the defect caused it. And crucially, it helps the claimant across exactly the barriers we just described. It adds rebuttal presumptions of defectiveness and causation, and it imposes disclosure obligations. When a claim is plausible, the manufacturer must hand over the evidence subject to trade secret protection. For defective AI products, the black box is being pried open by law. The second, the AI Liability Directive. This one was withdrawn. It was the fault-based complement, designed to ease the burden of proof for the wider world of AI harms that are not about a defective product. Harms from AI services, from discriminatory or negligent AI decisions, by introducing a rebuttal presumption of causation and a right to disclosure of evidence. It stalled. Industry pushed for simpler rules. Member states could not agree, And on the 11th of February 2025, the Commission listed it for withdrawal, citing no forcible agreement. That withdrawal became formal in the Office Journal on the 6th of October 2025. The instrument built specifically to lift the burden of proof for AI harm is gone. So where does that leave the person harmed? With a gap that has been selectively patched, generous in one lane, empty in another. If you are hurt by a defective AI product in the EU, you are now in a strong position. Strict liability, presumptions, forced disclosure. But step outside defective product and the flaw drops away. The revised Product Liability Directive covers personal injury, property damage, and data loss, but not pure economic loss, and not in general the dignitary and fundamental rights harms like discrimination that AI so often causes. And for fault-based claims across that whole territory, the directive that was supposed to ease your burden of proof no longer exists. You fall back onto 27 national tort systems, each different, each placing the black box burden back on you. And do not look to the AI Act to rescue this. The AI Act governs safety and risk management. It is not a compensation statute. It does not give a harmed person a right to be made whole. As one plain English analysis put it, there are currently no EU-wide rules designed to ease the burden of proof for AI-related harm outside the product context. Now cross the Atlantic because the American picture is starker still. The United States has no comprehensive federal AI liability law at all. Harms are addressed through state tort law, sector-specific rules, and contract terms. Courts are left to stretch existing doctrine, product liability under the restatement, and negligence onto a technology it was never written for. And they hit the same wall. A plaintiff must still establish causation through a system whose behavior even its makers cannot fully trace. Lawmakers, as one product liability analysis put it, are playing catch up, while courts, they apply frameworks built for static products to systems that are dynamic and self-evolving. Before I resolve this, the vote at the heart of the whole debate, when an AI system is a black box, no one can fully explain who should carry the burden of proof. Comment 1 right now if the burden should shift to the company that built and profited from the system. Comment 2 again right now, live, if the person harmed should still have to prove causation as in any other case. One word, where do you land? I'm watching you. And yes, those who are going to watch later, please do comment in the comment box. I'll reply later too. So tonight's puzzle, AI harms you. Can you prove it? And did the law just make that easier? The honest, verified answer is both at once, depending on which kind of harm you suffered. If you were harmed by a defective AI product and you are in the EU, the law just got meaningfully easier. The revised Product Liability Directive treats software and AI as products, keeps strict liability, and this is the heart of it, adds presumptions and disclosure duties designed to crack the black box open for you. That is a real closing of the gap. But for everything else, AI services, discriminatory or negligent decisions, pure economic and dignitary harms, and the entire United States, the law got no easier. And in Europe, it arguably got harder because the instrument written specifically to lift your burden of proof was withdrawn. There you still face the original crisis. Prove causation through a system no one can fully explain, alone against a party that holds all the information. So the liability gap did not close. It was selectively patched, sealed tight for defective products, left open for most of the ways AI actually harms people. And the deepest lesson is the one this pivot of the series was built to show. Closing a governance gap is not just hard to design, it is hard to keep. A law can be written to protect you and then withdrawn before it ever does, not because the problem was solved, but because agreement was not reached. Tonight's takeaway. For 9 nights, the pattern was the rules exist, but they lack the machinery to bite. Tonight adds the next layer and it is sharper. Sometimes the machinery is built and then dismantled. The AI Liability Directive was the machinery. It was drafted, debated for over 2 years, aligned with the AI Act, and then set aside because industry wanted simplest rules and states could not agree. The gap did not reopen by accident. It was reopened by choice. That reframes the work ahead. Closing the AI governance gap is not only a drafting problem, it is a political endurance problem. The revised Product Liability Directive shows the gap can be closed. Strict liability, presumptions, disclosure, all achievable. The withdrawn AI Liability Directive shows that even a finished design can be abandoned under pressure. So the task is not only to write good law, it is to protect it long enough to take effect and to make sure the person carrying the burden of an unexplainable machine is not left carrying it alone. The rules to make AI liability real are within reach. Whether we keep them is a separate fight. Where does this series go next? Deeper into closing the gaps, the mechanisms that actually work, the reforms on the table, and the fights over whether they survive. Tell me in the comments which gap you want confronted next. You help set the agenda now, live, 6 o'clock Central, every night from Thursday until Sunday every week. If these 10 nights, they actually added precision to how you think, do these 3 things. 1. Subscribe to both my channels if you haven't done yet. The AI Law, Global Security, AI Risks and Liability, and my second channel, AI Her Rights. 2. Join the mailing list at thoughtleadinnovate.com/newsletter. And 3. Tell me in the comments which gap I should confront next. You'll also find me on Substack, LinkedIn, Instagram, and of course my website, thoughtleadinnovate.com. This is the AI Law Daily, governed by evidence, guided by law. Good night and see you next.